On international law as a tool against democratic backsliding. My name is Diane Deserto. I'm professor of law and global affairs at Notre Dame Law School, where I'm also the faculty director of the LLM program in international human rights law. We have the great privilege today of listening to four exceptional human rights lawyers at a time when human rights in and of itself is already under siege in many parts of the world. In 2023, in their annual world report, VDEM, or Varieties of Democracy, observed or reported that apparently 72% of the world's population is now already under de jure or de facto autocratic rule. So thinking of a world where so much has already been normalized in the language of emergencies and in the language of repressions against human rights, this panel is interested in the continuing phenomenon of democratic backsliding and what international law can do to stop that continued backsliding. We have four excellent speakers today. One of our colleagues is online, and three of their colleagues are present here who will be talking on two very specific questions, and I will read both questions now. They will take each question in about 5 minutes of a discussion before we open up the floor. But before I discuss those two questions, let me first introduce the panel speakers. First and foremost, Shahrukh Alam, who is online. Good morning, Shahrukh, and I apologize that you are at 2 a.m. in India. That is not the ideal situation to be doing this, but we thank your commitment to contributing to this panel. Shahrukh is a very well-known human rights lawyer who's interested in constitutionality and in criminal law and its intersections with political power, identity, and class, and as I mentioned, practices law at the Supreme Court of India. After Shahrukh, who acts as counsel at the Supreme Court of India, she will be followed by James Cavallaro, who virtually needs no introduction, by the sheer fact, as I told him earlier, that he's probably one of the most well-known figures in international human rights law, being himself former president of the Inter-American Commission on Human Rights, having served as professor in international human rights law and directed clinics in the most well-known programs at Yale and Stanford, and is a very well-known advocate. He will follow after Shahrukh Alam's intervention. After James will be Olabisi Akinkugbe, who is to my left, who is assistant professor at Dalhousie University, who is a firm advocate and scholar of international human rights law and international law and its intersections, with a special focus on Africa and the particular conflicts within Africa. And then finally, to the left of BC, it will be Omar Shakir from Human Rights Watch, who is himself a very prominent advocate and most especially will be focusing his discussion on current developments involving Palestine and Israel. My task today as moderator is quite modest. I am here to provoke and invite discussion among four of the most eminent human rights advocates, scholars, and lawyers in the world. And to that respect, I invite Shahrukh and the other speakers to address the first question I will pose to them today. In an era of co-optation where all democratic, authoritarian, and semi-authoritarian states adopt the language of human rights, but do not consistently practice respect, protection, or fulfillment of human rights for their respective populations, how do you, as human rights counsel, scholars, leaders, and practitioners, distinguish between the legitimate differences in the interpretation and implementation of human rights vis-a-vis the pretextual invocation of human rights? When Vladimir Putin, for example, invokes the right to self-determination of peoples to his alleged special military operation against Ukraine, how can international lawyers, scholars, leaders, and advocates such as yourselves help guide the wider public in distinguishing between what is a legitimate difference of interpretation and what is actually just a pretextual resort to human rights justification that distorts human rights? Shahrukh, let's begin with you for about 5 minutes.
Thank you, Diane. Thank you for having me, and thank you, Priya, for having me. There's a very well-regarded senior editor here in Delhi, and he was speaking about democratic backsliding just today. And very pertinently, he says that it's not really democratic backsliding, but rather democracy leaping forward into a mutation. We can't really fall back on these older models of autocracy or unelected dictators or suspension of laws or proclamations of political emergency to understand what is going on. But rather, and I'm quoting the senior editor here, and this would be poetic if it weren't so awful. He says that the deployment of lawfare and the vocabulary of law and of good governance and that of the global war on terror looms as an autoimmune disorder of democracy. It's as if there is an autoimmune disorder in democracy. But anyhow, I'm actually recovering from a horrible day in court today. And I wasn't even a party, I was only an observer. We've had a problem of hate speech in India, to put it mildly. And the target of this systemic hate speech is the Muslim minority. There is episodic, offensive, even wild in speech, but this is systemic hate speech that I'm talking about. And it forms a wide spectrum. It ranges from genocidal speech, invoking direct violence, to that which encourages social boycott or economic apartheid of Muslims. And then there is the milder form of speech also, which is just moderately prejudicial. But cumulatively, it all forms systemic hate speech directed at a particular group. Now, this case that I'm talking about in court today had been brought about by petitioners saying that, look here, there is hate speech at such a huge scale, and mostly the proponents of this kind of speech are either members of the ruling dispensation or members of a political party or their sympathizers. And they're operating with apparent immunity. Nobody's taking any action against them. And this might lead to genocide. This might lead to actual violence. So why is the state so reluctant in responding to it? Why is the state not doing anything about it? And this was the case in court today. And everyone thought that they had a good case because this is not protected speech that we are talking about. But then something quite unexpected happened. The most senior law officer of the government of India walked in and insisted on playing 3 recordings before the Constitutional Court today. And these recordings were not part of his pleadings. So what were these recordings? He insisted on playing them, and he played them one after the other. The first one was a very militant speech by the leader of a vulnerable caste group, where he was talking about annihilation of caste and oppression. And he was calling upon his caste members to come together to overthrow the forward caste ruling elite. It was militant, it was offensive. The second speech were some Muslim groups celebrating the supremacy of their religion. It was also exclusivist, it was also offensive. And the third one was dissenting speech by some rebel groups, and they were basically calling the government of the day names. They were abusing the government. But the senior most officer playing these 3 clips in court before the Constitutional Court was making another point. He was saying that court is being partisan in selecting only those speeches that are anti-Muslim and picking them out for action. He challenged the court. He said, why those speeches? Why not these? Why not the speech by the Muslim group? Why not the speech by the dissenting group? Why not the speech by the vulnerable caste group? And in doing that, he equated these episodic offensive speeches with systemic hate speech, which is a problem in international human rights law. That is a problem, because there is the principle of variable context. There's also the understanding that hate speech is systemic. It's not a problem of offensive speech. It is a problem of discrimination. And hate speech is only that kind of speech which is inflected by a certain social political power that has the backing of social or political power behind it in a way that it can actually cause material harm to the people to whom it's directed. It can cause a democratic deficit. So therefore, these other marginalized groups making these episodic speeches do not amount to hate speech. That is what international human rights jurisprudence says. But what we are also finding out is that the prerogative state, a state that is inflicted by this autoimmune disorder of lawfare, does not give any space for normative law. It does not give any space for evolving jurisprudence in law. So the prerogative state is also coming in the way of normative law. And that is a problem that we are facing in India today. Thank you.
Shahrukh, thank you so much for that last point, especially on the very precarity of lawfare. Turning to James on this precise question.
So, in 5 minutes, I wanted to frame the entire debate with a couple of observations, and I'll do that very succinctly in bullet form. Tony Angie, in his talk over lunch when he was being honored, just emphasized at the end how international law has been, throughout its history, great powers law. And that's a useful frame, I think, to have at the 30,000-foot level. Within international law, the body of law that has the greatest possibility to advance ethical agendas, I would say, is human rights law. If we look at the context and the crisis that the world is living today with quote-unquote democratic backsliding, I think one of the critiques that we should make of the human rights movement, and I will quote Sam Moyn, my colleague at Yale, on this point, is that we in the human rights movement have advocated for a relatively thin understanding of human rights. We respond to atrocities primarily. We have focused on civil and political rights abuse. We have not made economic justice, distributional justice, and environmental degradation and planetary destruction the focus of our work until relatively recently. Those issues matter because I think what we're experiencing now is a delayed response to a decade or two where we were kind of okay with the planet being in the context in which it was, with formal democracies in many parts of the world, most parts of the world, with formal representative structures, individual civil rights respected, but fundamental gross economic inequality and rampant inequality between the global north and the global south and within countries. I think what we're seeing now as countries are blowing up is folks are not happy with that neoliberal global consensus aligned with a discourse from human rights of ethics. And then the last thing I'll say is, because I'm here to talk about the Western Hemisphere, if I understand who's on the panel, and if we're talking about democratic backsliding, I'm a permanent resident of Brazil. I've lived and worked in Brazil for off and on for the past quarter of a century, in Chile and other parts in the hemisphere. And you cannot appreciate and understand democratic backsliding in Latin America without appreciating democratic backsliding in the United States. The last authoritarian leader of Brazil is in Florida now. Didn't pick that spot off a map, folks. There are strong connections between the far right, between evangelical right-wing movements, between efforts to limit democracy, to move towards semi-theocracy, strong connections between that in the United States and what's happening in Latin America where you have democratic backsliding. And then to answer the question, which now I think I have a minute and a half, 2 minutes.
You still have 2.5.
2.5 minutes, plenty of time. Do a 2-minute drill. Sorry for the sports reference. To respond to this question, how can we know when authorities or non-authorities use human rights discourse to advance agendas that are contrary to the core values of human rights? And by the way, Vladimir Putin is a great example. Miserable SOB, Vladimir Putin. Responsible for war crimes, absolutely. But friends, Vladimir Putin does not have a monopoly on twisting and distorting human rights discourse. I'm reminded of something that I assigned students to read, which is a piece written by your former boss, my former boss, a guy named Ken Roth, which is The Invasion of Iraq is Not a Humanitarian Intervention, which is a piece why would you write that piece? You write that piece because the United States, after it didn't find WMDs in Iraq, was spinning its intervention in Iraq, which violated international law, as a humanitarian intervention. So, folks, we've got many, many, many decades of many countries, mostly powerful countries, spinning human rights discourse for purposes that do not align with human rights. How can we tell what's real and what's BS? And the answer here, it's not easy. This is a fact-based inquiry. You need to understand what is happening. And the best way to do that is to be in the locale. Can any one of us be in any locale in the world? No. So what do? We delegate, so to speak, that decision-making or that factual analysis to those who we trust. We used to more or less be able to do that with the media, but one of the problems we have over the past decade is we have very few media sources that operate at a global level and are doing that kind of documentation. Everyone has a cell phone, everyone is on WhatsApp, everyone is a journalist. There's a flood of information. We can't discern between what is BS, what is misrepresentation, what's reality. What we have to do then is identify organizations that have values that align with ours and basically delegate to them. Maybe Human Rights Watch, maybe not. Maybe I question Human Rights Watch on some issues, maybe Amnesty, maybe local organizations, but it's a fact-based inquiry. There's no magical wand that we can use to discern between misrepresentation and representation. The discourse is malleable, and this is the one last thing I'll say, because my time is up, is one of the challenges we have in human rights. I started human rights almost 4 decades ago, in the 1980s, and we were largely irrelevant, those of us advocating for human rights. And part of our becoming relevant and part of us making the field of human rights relevant is now we have folks who recognize this is a potentially valuable discourse. Let's co-opt it, let's seize it, and let's use it for our interests, which have nothing to do with human rights. So it's a very different challenge than we had 3 or 4 decades ago when no one listened to us.
Thank you very much, Jim. So we've heard from Shahrukh talking about the autoimmune disorder of democracy and how there's no space for normative development of human rights law, ironically, in these times, especially with a classic study of hate speech. And Jim has very rightly pointed us in the direction of a fact-based inquiry. And this leads me to our third speaker, Professor Akin Kugbe, or BC in particular, where especially when it comes to Africa and the depiction of Africa and international law, how, in the context of the question that we've raised here, how do we distinguish between legitimate differences of interpretation and the pretextual invocation of human rights law?
Okay, so thank you very much, Diane, and it's nice to be with you guys on this panel. So I think before going to your question, there's something I'll just respond to. When James, for example, says he mentions his colleague Samuel Moyn and says we in human rights. I'm not a classic human rights scholar. I do international economic law with interest in human rights. But I question who the we are, right? Especially if you mention Samuel Moyn in that line. I respect his work. But if you mention Obiora Okafor, you mention Makar Mutua, you mention many other scholars who write about this work from other regional contexts, then I think the articulation of human rights in a narrow sense you see is being written about in the broader sense in other contexts, especially from the work of the African courts on human rights. So that's just a footnote. I also think that, the place I want to start is really, number one, around conceptualization of the notion of democratic backsliding. I want to push back on the idea that it is what is happening everywhere and that it is what we should know. And that it is the lens through which we should view everything. My initial short answer is nope. That's not the truth. It happened in U.S. When U.S. thought it was sitting on a democratic practice that should be exported. From the African context, I think on that point, to just concretize it, it's interesting that, folks have spoken about protests in Tel Aviv, protests in Brazil, And then you can trace it to his grandfather in the US that we are, right, to January 6th event. But not so much has been said about the protests. In Kenya, the protests, in South Africa, the protests, in Nigeria, where we recently had elections, successful elections. What's more interesting is that the nature of the opposition that is leading the campaign is not by those who won the elections. It's frankly opposition parties, energizing their base to essentially attempt to delegitimize a regime that is in power, right? And quite interestingly, the regime that is in power is allowing it. That is democracy in my view. I don't think that's democratic backsliding. That is pushing the boundaries of democracy. And so in the African context, even though we know a lot of these countries, turned the tide in the late 90s, early 2000s to their democratic practice, I like to say in the context of the African states, it is maturing. Of course, I will also be careful not to suggest that's the story for every African state. So you can look at Gambia, you can look at, some other states and say, well, be careful in there. So we have to be cautious of not generalizing that. That's conceptually. Number two is, this era of democratization of internet and the information that comes with it and Twitter, you can literally tweet anything. And so you think about the African context and you think about the Nigerian society. As a Nigerian, I ask myself, how many people who have data in their phone, has access to internet, know really about the bots that are really circulating these divisive tweets out there, right, that are finding the base of various ethnic groups against the other. So when you talk about hate speech in the Nigerian context, that's also played out in the current election that I just held. And it's tough because the opposition strongly are saying, for many reasons, including the fact that certain persons have made hateful speech from the other party, we see what you guys are doing. So in the context of, democratic backsliding, I think the notion that democratic backsliding isn't happening should also be, if you like, paved or complemented by the notion that there are different ways in which practices in various countries show backsliding, right, in the recognition of human rights. The notion that, you sit somewhere and you say of another tribe, they should leave this particular state and go to their home state. Now, that's a concern, especially when it has tribal dynamics on it. I think that's playing out in some sense in Kenya. It's playing out in some sense in other parts of the continent. Number 3 point, and then I'll stop because I'm under 1 minute, is to say that, look, cooptation hasn't happened in this way, right, by the winning party. The language of what is legitimized interpretation of human rights is actually playing out in how it's being weaponized by opposition parties who are finding their base, as I said at the beginning, to attempt to just carry on. And if you like, it's sort of the Trumpian nature, where you're out of office and you just continue to campaign around the country. And so this is not quite campaign. It is stern opposition, political rallies, and I think it's not democratic backsliding in my view.
Thank you very much, BC, for that view. I mean, you can see the inherent polemics with this question when you've got the most eminent human rights lawyers and practitioners on this very same panel having multiple views about the applicability of human rights, about the assessment of what is backsliding, and the nature of the inquiry that is important. So on the point about the nature of inquiry, I don't think I can ask anybody else better to talk about fact-finding and human rights fact-finding in the context of this legitimate differences between human rights interpretation, which is just the ordinary polemics of human rights, and the pretextual invocations, because the fact-finders are supposed to be the ones that we can repose trust on. So on that note, let me invite Omar Shakir from Human Rights Watch.
Well, thank you, and I think you answered my question for me. The answer is quite simple for us at Human Rights Watch. The answer is meticulous research, and it is principled application of the law. The idea is the same principles should apply regardless of the context that you're dealing with. And that's a tall order, right? Because invariably everybody wants to exceptionalize their particular circumstance. But really, the real answer to your question, as a practitioner, is it kind of doesn't matter to the general public whether it's pretextual or whether it's the stronger argument in court. Because at the end of the day, if the human rights abuser can persuade the general public, can persuade the powers that be that they're acting in accordance with international law, that's going to carry the day. So part of the work we do at Human Rights Watch is to speak to the concern, directly try and deconstruct the argument and get to the heart of the matter, right? So, let me give a couple of examples. For me, it even dates back to when Jim talked about these principles in the Middle East. I documented one of the largest single-day killings of protesters in Egypt. And the government there tried to justify a dispersal, a planned massacre by saying, well, what about your right to work? What about your right to having, to go about your everyday life? And why is the right of this minority trumping that majority right? But in the context of Israel-Palestine, take one example. In 2018, when thousands of Palestinians in Gaza went to the fences separating Gaza and Israel, demanding their basic rights. And the Israeli forces, and this was also a planned operation, opened fire on protesters. They gunned down dozens of protesters. Now, the argument that Israel used at the time was, well, these people were members of armed groups. In essence, using a law of war paradigm for what should be governed under a law enforcement human rights paradigm. But to the average person, and this is happening today, by the way, if you're following the raids taking place in the West Bank, you'll see that Israel will say, well, look, 9 of them were militants, but this is a law enforcement operation. It's not a situation of armed hostilities where you apply a law of war framework. So take the very same analogy. If there's a protest here in Washington, D.C., and people who are participating may have been convicted felons, does that mean the police can just gun them down because they're at a demonstration? So in some cases, to make the argument, you have to take what seems like an exceptional situation, decontextualize it, put it elsewhere, and see what happens. By the way, it applies by abuses by the Palestinians as well. So for example, we've documented rocket attacks by Palestinian armed groups. And I've had exchanges, letter writings with Hamas officials where we'll say, this is a violation, this is a war crime. And they'll say, well, we have a right to resist. We're an occupied population. Yes, you have a general right to resist, but actually when it comes down to the means and mechanisms of using force, the same standards that we hold the Israeli army to is what we hold armed groups to. So it's the ability to basically take the argument, decontextualize it. But before I conclude, I do want to sort of add on to the last two presentations in terms of this idea of democratic backsliding, especially when we talk about Israel. And I think the debate that we see today is, well, there's this authoritarian grab and these protesters are trying to save democracy. But what most people, I think, forget is democratic backsliding implies that if we were to rewind the clock 4 months, we have a situation of democracy. But as many of you know, millions of Palestinians have lived under Israeli military rule for well over 56 years, denied their basic civil and political rights. They have basically no say over the government that controls their everyday life. They had that 4 months ago, they had that 4 years ago, they had that 4 decades ago, but that doesn't factor into the conversation. Hagai Elad, the executive director of Israel's premier human rights group, B'Tselem has written that democracy is the rule of the people, not the rule of one people over another. So I think it's important to understand, anytime people take to the streets in a demonstration, it's important to listen to grassroots voices. But the entire construction of this debate is about democratic backsliding, I think misses really what's the elephant in the room, which is between the Jordan River and the Mediterranean Sea, you have one government that rules over 2 population groups of equal size, where its policy has methodically been to privilege one people at the expense of another. And that has to be said, before we go further in this debate.
Thank you so much, Omar, especially on this point about decontextualization, and not everything is a binary debate between the forces, the Manichaean forces of democracy versus the forces of autocracy, that maybe there is room for nuance and context and history and fact-finding in how we undertake the human rights debate. On that note, therefore, if as has been articulated as well by Sharuk and by Jim and by BC and by yourself, it's important to do this kind of rigorous inquiry at many levels. Jim says you have to go to the locale and make sure that you really understand what is going on. BC says, well, maybe it's not really backsliding because you also have to take into account who's asserting the right and trying to make it look like there is some sort of backsliding. And as you pointed out just now, that the decontextualization, applying a same set of facts to a different context, whether we think this exceptionalist behavior is indeed in violation of human rights, what do we do when the traditional institutions that do this, and I'm talking human rights defenders, investigative journalists, history writers, education, academics, and judges who are in the process of issuing judgments, are themselves under attack. And they're under attack for many of the reasons that we've been seeing, especially in the latest reports coming from Freedom House, coming as well from Human Rights Watch, which is one of those reports that I also saw, where the attacks are no longer just about physical attacks or injuries inflicted upon journalists, judiciaries, environmental and labor human rights defenders, professors and teachers, but actually they're attacks that are used to discredit the expertise of these persons, their professional reputation, their credibility, their reliability, to destroy their independence and the public's trust in these institutions or these persons. And at its very worst, there can be a toleration or impunity for assassinations where there's no crime that's solved, or murder or of any kind that's solved in regard to these particular persons who are supposed to help the public in conducting this inquiry. How then do we wield international law to arrest these attacks? And I'll go in reverse order because I do notice that Sharuk began our panel, and I'd like to finish with her remarks as well, especially since we began with hate speech. So possibly about 3 minutes, and then after the panel finishes on these points, I'll invite comments from the floor. Omar, I'll begin with you.
Yeah, thanks so much. So, I'll start by, the Middle East is the easiest context in some area because we have no effective accountability mechanism. There is no regional human rights court. There isn't, whatever the situation you're looking at, you're really not going to find many mechanisms. There isn't much respect in the underlying norms by the governing authorities. So how do you deal with that kind of situation? I think I'll take the example of Israel-Palestine because that's the one that I work on. And I think what we've tried to do is to ground the understanding and discussion of the reality on the ground in international law as a way to shift the paradigm and as a way to call a spade a spade. So in the situation of Israel-Palestine, for example, we spent 30 plus years at Human Rights Watch looking at specific human rights abuses in specific areas. Freedom of movement in Gaza, use of force, killing of children in this area. But we took a step back 5-6 years ago and we said, you know what, let's write a report that understands how Israel treats Palestinians. We spent 2 years doing vigorous fact-finding, case studies comparing the treatment of Jewish Israelis and Palestinians in different areas, West Bank, Gaza, Israel proper. We then looked at statistics and trends in 30 years of our research. We looked at the work of our Palestinian, Israeli, international partners, and we looked at statements by the Israeli government. So we wrote this 200-plus page detailed factual account of how Palestinians are treated. We then applied the law, and there's a term under international law for severe discriminatory oppression, and it's called apartheid. International treaties define apartheid as a universal legal term. It's the term in the International Covenant on the Elimination of Racial Discrimination, and it's a crime against humanity, set out in the Rome Statute as one of the 11 crimes against humanity. And when we applied the facts that we documented to the law, we found that Israeli authorities are committing the crimes against humanity of apartheid, which as a crime against humanity basically means severe abuses known as inhumane acts when they take place in a context of systematic oppression by one group over another and where there's an intent to maintain that system. And we also found persecution, another crime against humanity, which I'm happy to talk more about in Q&A. But the bottom line is, when we applied the facts, it was a slam dunk case. You had a very transparent policy to maintain the domination by Jewish Israelis over Palestinians when it comes to demographics, control of land. It's set out pretty clearly in planning documents, and I'm happy to go into details. I can't do it in 3 minutes. We go into the systematic oppression, the dual legal regimes in the West Bank, the closure of Gaza, etc. And we go into the inhumane acts, the movement restrictions, the land expropriation, and by calling, a thing by its name, by calling it apartheid, you then help to shift the conversation away, because a 56-year occupation is not temporary. Denying millions of people their basic rights because of who they are is not simply an abusive occupation. We've now seen this moment where there's a consensus in the human rights movement around apartheid. It's Amnesty, it's Human Rights Watch, it's Palestinian Civil Society, who's been saying it for years, it's 27 Israeli human rights groups, it's UN experts, it's Harvard Law School's Human Rights Clinic, it's 120 Israeli law professors just earlier this month. So by doing that, I think we can push back by grounding the discussion, the discourse, even here at ASIL, in the reality on the ground. Because once you do that, the first step to solving a problem, and I'll end here, is to diagnose it correctly. The wrong diagnosis leads to the wrong analysis and the wrong set of recommendations. So the more you can tie facts to reality and doing it with serious methodical research and legal analysis, the faster we are to getting human rights-based answers and mechanisms.
Omar, thank you for the most radical proposal I've seen, which is to apply international law to facts on the ground. It's a comfort to say that here at the American Society of International Law. Let's continue with BC.
Thanks. So, accountability mechanisms. I think the first thing I'd like to put on the table is that in the national context, if we're thinking about the role of courts, for example, one dimension of it is to simply say the national courts have not been helpful in bringing accountability, whether it's in the areas of actions taken against academic scholars, judges perceived as wrong, or journalists in terms of violation of human rights. But I think there's another dimension to that. If you look at the effective where cases of election violations or processes that have gone wrong have been judicialized, you do see that the courts, national courts, draw on international law frameworks, treaties, those that have been domesticated in their constitution, as Kim's Grotius lecture alluded to yesterday, as one dimension of certain role that international law can play, just to fix it, connect it to the theme of the conference as well. So that won't be limit, right? But it could be limiting in the sense that there's only so much that the decision can be useful in the national context. If the government that is in power is the government that is conducting the election, right? So if it's not about the opposition being the party that prevails in court, then there's a challenge about how far the judiciary is truly free to do what it has to do. So in the African context, you've seen the judicialization of a lot of election disputes in the courts. And I think, Kim Shepard's fantastic Grotius lecture yesterday could have alluded to a lot of these works that have taken up in the African context. Works by James Gathie, Corinne Alter, a lot of other people have written about this in their political context. And so I think that's where you do see claimants actually weaponize, right, in a very strategic way, the language of human rights to get the cases to the dockets of these courts to start with, right? And so once couched in the language of human rights, the courts have jurisdiction, and then they can effectively adjudicate on that. So if you're thinking about accountability mechanisms, I think regional courts in Africa are indeed at the forefront, right, of trying to do this. Have they been effective? That's a thing around which we can have a longer conversation. I can't say so in 3 minutes, but I think a lot of their decisions have been useful for other kinds of strategic purposes that puts the government on some kind of slow movement. The last thing I'll say is, it's important to note that, democratized disinformation is a challenge, right? And so the example on which I'll end is, Nigeria's election has ended. It's said that the president-elect is somewhere in Europe. For whatever reason, we don't know. But then suddenly you hear, the Chief Justice of Nigeria is suddenly in Europe. And then the next thing is, he's meeting with the president-elect. And then the Supreme Court of Nigeria is forced 48 hours later to release a video of the Supreme Court of Nigeria walking to pray on a Friday. So I don't know what you make of that, but that's where I like to put it, right? I don't know what it means for the judge who has to effectively, who one day may have to have these cases on their dockets involving the parties whose supporters are making this kind of allegations.
BC, thank you very much for that. I'm finding a recurring theme here because the equally radical proposition is let's activate the national lawyers to work in the regional courts and hold government leaders to account, as well as to question the narratives that have been predominant with respect to human rights violations and their alleged perpetrators. Let's turn to Jim.
So I have to respond to BC, and I will respond by thanking you because I entirely agree with what you say. And thank you for catching me in using the first person plural to refer to the principal human rights organizations in the global north. I should have said the principal human rights organizations in the global north, as Sam Moyne says in his critique, have focused on civil and political rights and have not addressed distributional inequity and have not addressed some of the structural grave problems that humanity faces. So I stand corrected on that. Part of that I use the we, part of it is a mea culpa because I worked for Human Rights Watch for many years and because I'm at the American Society of International Law. Whose overall composition, notwithstanding Twale and some other folks, historically, has probably been largely on board with the views that are the first person plural when someone who is a citizen of the United States, who is trained in universities in the United States and is a professor in universities in the United States, uses the we. But thank you for calling me out on that because I shouldn't do that. I always call it out when my students do it. But so I totally co-sign what you have to say. I think the question is, and then I'll get to this, the question I'm supposed to answer very briefly. But I think the question is, what human rights movement do we want in the 21st century? We're beginning to see, and it may be too late, friends. I honestly think it may be too late. Maybe Macau's right. You know, I worked with Macau. I know Macau. Maybe he's right that we've missed the focus areas that we need to address for too long in the human rights movement. But you see now litigation before the International Court of Justice, before the Inter-American Court, before the European Court on climate change, right? This is an issue that the human rights movement should have taken up as a core human rights issue a decade or 2 decades ago, okay? We're taking it up now. That's great. We're playing catch-up ball. Sorry, second sports analogy. But we may be able to, overcome the hole that we've dug for ourselves. We may not. And then in terms of just to answer the question factually, in the Western Hemisphere, the inter-American system, and this is also part of the critique of the thin approach we've had to human rights, is pretty good at providing a mechanism to protect those who are facing death threats. Are rights defenders and journalists killed in the Americas? Yes. More than in most other regions or all other regions of the world? Yes. But there are some mechanisms to respond. Precautionary measures before the Inter-American Commission, before the provisional measures before the Inter-American Court. But again, the issue is what are the underlying causes of environmental rights defenders being threatened with death, of rights defenders being threatened with death, et cetera, and can the human rights movement, can international law respond to those? I don't know.
That's very intriguing, Jim, because we see a recurring theme, at least with the discussion we've been having so far. It almost seems as if nothing is awry with international human rights law in and of itself, but the users of the system and the contexts under which international human rights law is deployed often will have very different effects. And we haven't spoken about the role of movements and how they can protect and how they can defend. Turning to Shahrukh, because we began with your very provocative insight that there is potentially no normative development in international human rights law when lawfare is now the predominant autoimmune disorder for democracies. Do you see a human rights space here, particularly in that normative development to take into account actively protecting those who are trying to do the rigorous work of fact-finding and investigation and prosecution and the narratives that we want to tell our children in the future about how human rights and human dignity are defended here today.
Diane, I want to step back a bit, and I want to add to what Jim and Omar said in the first round about backsliding not happening without a context. It doesn't happen in a vacuum. I want to step back too, and although our problems, frankly, Omar, pale in comparison to yours, but having said that, in India, we have inherited just one example of a structural problem in law. We've inherited a criminal justice system which is colonial. And just as an example, in India, in the criminal justice system, arrest is the start of the investigative process. Arrest does not happen at the end of the investigation. It happens right at the beginning. So when an offense takes place, when a crime takes place, the first reaction of the police, which is really inheritors of the colonial police, are to bring everyone in. They said, just bring everyone in. And custodial interrogation is recognized in law. It's a doctrine. So you arrest people, you keep them in jail, and legally, the police in India are allowed to keep people in detention without charge for up to 90 days for usual offenses. And now add to that other conditionalities that came to us together with World Bank grants or IMF grants that talked about clean governance, that talked about doing away with corruption in public life, good governance, etc. So on the basis of this structure, which allows arrest without charge for up to 90 days, we introduce things like immediate suspension from government service for those arrested, or disqualification at the stage of first conviction from public office. So these are problems that we have built upon a faulty structure. Now, Umar, we also in India have always aspired to be a hard state, a muscular state, aspiring to be like Israel. We had a major terrorist attack in 2008, the Mumbai terror attacks. And after that, we brought in draconian special acts to deal with what we call terror crimes. And the law minister at that time, in 2008, said in Parliament that this is our gift to the nation. What we are gifting to the nation are not better hours for the police, not better investigative techniques, but we will now allow you to keep suspects under detention for up to 180 days. So 6 months on a terror charge without any kind of information about why you are in jail. This is what had already been happening. But what is now happening, the very quick backsliding, the democratic backsliding, is that arrests are now being made or offenses are now being tried under these special terror acts, which needn't be so, which are very ordinary offenses, but people are booked under special acts. And a lot of these are speech acts. And a lot of these are acts of political association or political mobilization. And that is where the democratic backsliding comes in. If you're organizing against the government, if you're challenging the government, then you are arrested under a terror act. And the other problem with this is that it is targeted at certain groups. If you're Muslim or if you belong to a vulnerable caste, then invariably you are arrested under these terror laws. And before I end, in a very ordinary case of political mobilization, some young Muslim students have been arrested under terror laws. They have been in jail now for over 3 years. The prosecution's case is that they had conspired to internationally further the propaganda that minorities in India were being oppressed and to embarrass the government and to embarrass the visiting President Trump when he visited India. Now, there's an obvious fallacy with this. Nobody could have conspired to embarrass President Trump. That's just wishful thinking. But anyway, that's the prosecution's case. They also say that these people conspired to provide Muslims an articulation of their grievances and a methodology for its articulation. That's a basic democratic right. It is now being turned into a terror offense, no less. Reading on, they say we created a critical mass of Muslim protesters, communalized political space, which could have led to violence. This is a terror charge. We've come here partially because of the global war on terror. So the answers also must lie in new guidelines in international human rights law about what should be the threshold for a terror offense. What has to be the minimum threshold for framing an offense as a national security issue? Otherwise, it's forever expanding.
Thank you very much, Shahrukh. And on that last note, on the normative, purposive normative development of human rights law to take into account defending those who are seeking to ensure its implementation, its lived reality for everybody else in the world. I have an administrative task, which is to remind everybody if you need CLE credits, you must get it from somebody at the door. But for now, we have time for questions. Please introduce yourself and please try to make it a question. If it is a comment, please try to reserve time as well for others who will want to weigh in. Thank you.
Hello. Thank you to all the panelists for a very interesting discussion. My name is Mariam Jamshidi. I'm a professor at the University of Florida Levin College of Law. This question is for Omar. Very excited to see you at ASIL. It feels like a momentous moment to have someone speaking about Palestine on its own terms, so that's very refreshing. My question is, and apologies, I came in a little bit late if you already answered this. Would you call what is happening inside Israel right now democratic backsliding? Or would you describe it in a different way? I'm going to provide one potential alternative explanation. Would you call it sort of inevitable result of a state built on the foundations of settler colonialism?
Thanks for that question. I think I would so my initial instinct is to say the frame of reference is critical, right? So, I mean, the green line, while it matters legally, I mean, we apply the law of occupation, the OPT, we don't inside Israel, but as a factual reality, there is one government that primarily rules over the area between the Jordan River and the Mediterranean Sea. And I think part of the challenge and the way people view things is to view democratic Israel and occupation as two separate entities, when the reality is the very same government, the very same ministries that operate inside Israel proper operate in the OPT. For Jewish Israelis, they can move across settlements back to Israel freely. They're governed under the same system of laws. They have the same rights and privileges wherever they are. Palestinians, yes, face different legal regimes, but no matter where they live, they're discriminated against. There isn't a square inch of territory between the Jordan River and the Mediterranean where Palestinians and Jewish Israelis are equal. So that's why I have trouble saying, can you carve out this section and say, is it democratic backsliding? Now, if you were to ask me a different question, which is, is it democracy for Jewish Israelis backsliding? Yes, then I might say that. But, to say that I'm going to look at only one of the two population groups is a different sort of issue. And even within Israel proper, Palestinians face systemic discrimination. And so, I mean, apartheid isn't a regional anachronism, right? I mean, Palestinians everywhere face discrimination and the same system it's part of the same system that Palestinians in Israel, for example, are citizens but not nationals, have limited access to land, attend separate schools, have restrictions on jobs they can get. So that's why I have a difficult time doing it, doing that inquiry. But if you were to carve it out in that way, it might be a bit different. And in terms of settler colonialism, look, I think there's been very valuable writing done, but as an international lawyer, right, our frame of reference is to look at the legal term. So apartheid, is a term with a definition, has a convention, it's in the Rome Statute. There's incredible academic work done in settler colonialism. Palestinian human rights groups like Al-Haq, they just did a major report in November putting apartheid in that context. I encourage everybody to read that, but we stick to sort of the legal framing at Human Rights Watch, for better or worse.
Thank you. Do we have a next question?
Thank you. My question can be answered by anyone on the panel. I am curious We've been talking about democratic backsliding, and we've been talking about the promotion of democracy over the last 2 days, but we haven't really heard from any democracy and governance practitioners. Maybe they're all down the street at the Summit for Democracy. Democracy and governance practice has been around now for about 40 years, and I was part of that for maybe the latter half. And I don't think, well, the entire time that I've been in the DRG field, we've been talking about democratic backsliding and having to counter arguments about it. I don't think many people in the field really ascribe to that narrative anymore. And it's not because some places are moving forward, some places are moving back. We can't, of course, dispute VDEM or International IDEA, any of these reports, but it's because that we're working on so many fronts at once. It's more of a game of whack-a-mole. It's more a game of fighting mutations, as Professor Alam put it. It was interesting to hear the example of Kenya that Mr. Olabisi raised. I woke up this morning with a WhatsApp group of my Kenyan colleagues, all of whom are Kenyan, comparing the Maandamano experiences in Nairobi and Mombasa and Kilifi County, and seeing when we would cross the line from peaceful protest and demonstration to perhaps something, and then asked me the question, when did you know on January 6th? Those are the questions that we really deal with in this field, and it would be lovely to hear the perspective of the folks who don't just show up on election day, who don't just show up when, or document the massive atrocities and abuses, but who work with the legislatures. We haven't heard legislators mentioned, by the way, political parties and civil society behind the scenes to help build those pillars of democracy. Thank you.
Please take the question. Thank you.
Okay, so that's a lot of question in there, but I think what I hear you, asking is articulation in the latter sense of, why the legislature has been quiet. How do we understand this in the context of the work of democratic practice? I think what I would say is, from what's happening again in say Nairobi and Mombasa and letters to governors, for those who don't know, if you get on Twitter, you would see this very civil exchange between two governors of, two counties in Kenya, which I think is a very good demonstration, again, of a region that's been so written in a very terrible way, but, very excellent practice of civil disengagement about when, protests is too much for the business place like Nairobi. So to come back to your question then, how do we take that, right, vis-a-vis potentially the role of legislature and understanding it in the wider context? I don't think there's one straight answer, right? So I don't want to pretend what I'm saying is one silver bullet. But one dimension of it is where I go back to in my own work, to ask myself, really, what is the role of the courts in this? And I don't mean national courts. In the African context, I mean regional courts. Because that's where there's hope for us on the continent, right? State capture, executive capture, whichever concept we want to use, really has dominated the national space, such as so difficult to really get that sense of justice in the way you want in there. And I think in this regard, my own sense, to give what is maybe a version of an answer, is that in the African continent, that's where you see the work of human rights activists and movements, right, as you said, who see this, not the political parties themselves, but who want to lay something on the ground, simply as saying, let's take this to court. Even if the outcome is that we lose this particular case, posterity is there. We will make sure this flies on the pages of every international newspaper, right? That does something for the future. Right. But again, like I said, you asked a question which I don't think one can pretend to answer in one silver bullet answer, but that's one version of an answer I can give.
And on that note, we are at the top of the hour for an extremely rich set of discussions in this panel. I invite those of you in the audience who did not get to ask your questions to please feel free and harass the speakers as they get off the podium. We can keep discussing this over tea or coffee, but for our part, we thank the speakers, Shahrukh Alam, James Cavallaro, Olabisi Akinkugbe, and Omar Shakir for being here and lending their insights on one of the most crucial, pressing questions for international law and international human rights law. A wonderful afternoon to everybody.